Alrighty, folks, looks like we are live. Looks like my audio and visual are good to go. If not, let me know. I'm George. I'm one of the founders of SoloSuit. I'm going to be going over how to win your debt lawsuit today. Going to be going over some of the basics. I'm going to take a few minutes in the beginning just to review the basic process. We reserve most of the time for a Q&A, so if you have a question, go ahead and put that into the chat on the YouTube chat. Our wonderful Hannah at SoloSuit will also be responding in the chat by text, and I'll be responding to your questions verbally. This is not legal advice. I'm not an attorney. I'm not your attorney. SoloSuit's not a law firm. We don't represent you if you use one of our services. So just a webinar shouldn't be construed to be legal advice, and I give that disclaimer just because of regulations in the space. All right, well, let's go ahead and get going. So the basic idea here is most of you guys are here because you probably received a summons and a complaint. All right, so summons and a complaint. When you get a summons and a complaint, you got to respond by filing an answer document. All right, this is a capital A answer document. It's like a formal legal document. They needs to be like properly done in order to be accepted by the court. Once people file an answer document, oftentimes people want to settle. Most of our customers want to settle. If you do agree that you owe part of the debt, then it's the best resolution. It's going to be the tidiest way to wrap up the lawsuit. Sometimes, if you feel like you're being sued incorrectly, if you don't owe this debt in any way, if they got your identity confused, you probably don't want to settle. You might want to just aim for getting the case dismissed. All right, so our product, SoloSuit, our debt answer, it helps you respond to the lawsuit. We create an answer document. You create it using our software and our website. Then we have an attorney review it for you and we file it for you in court. With settlement, most people want to do our product called SoloSettle. With that, you can make an offer to settle using our software. And we even have something called, it's a beta service, but it's called SoloSettle Premium. Specifics are subject to change, but we'll connect you with a law firm that will take care of you and get your case fully settled. Okay, so those are some of the basics. We have a lot of people on here today, so you want to make sure you get your question into the chat. And then, something a couple things that are important to note. I really want to emphasize the great success of SoloSettle Premium. We're seeing great results. We had one person who had a $26,000 debt settle for only $11,000. So they got more than half of that debt hacked off, totally settled, big savings. They settled for less than 50% of the total amount of the debt. We had another person who had settled for, who had saved $4,000 through settlement. So if you want to get savings like that, SoloSettle Premium is the way to go. You can just file an answer through our service, and then you go over, make an offer to settle, and you sign up for SoloSettle Premium. If you want to do that, I'll actually put the link directly in there into the chat. Right now, just uno momento, and I will put that in there. All right, so you can check out, there's the link, you can check that out. Basically the process here is you want to make an offer first at solosuit.com/solosettle. So you make an offer there, and then at the end of that process, you'll click the link to activate SoloSettle Premium, which is that link that I just put in there. And then you can sign up for that, and we'll get you all taken care of. We'll get that lawsuit settled, hopefully save you thousands of dollars. Results aren't guaranteed or anything, and every case is different, but a lot of people are saving significant amounts through SoloSettle. Right now, people are usually settling on average for about 64% of the total amount of debt. Okay, so big range. Some people settle for as low as like 20%. Some people settle for 80%. But the median is 64%. So that means most people are saving like 40. What does that come out to? 36%. People are saving 36% oftentimes. All right, so that's a big win. So go ahead and check that out. Definitely best resolution for most people that come to our site will be through SoloSettle Premium. Okay, jumping into the questions. Again, thanks for showing up tonight. Glad you guys are here. Definitely want to help you win your case. All right, Michelle. Do I have to respond to discovery motion if I filed a motion to invoke arbitration after? Interesting. Okay, so going to this here. So it sounds like you got a summons and complaint, and then you filed an answer. And then what happened next for you was you got a discovery document. I'm not exactly sure what a discovery motion is. Maybe like a request for admissions or interrogatories or something like that. And I guess before that, you had filed a motion to compel arbitration, what we oftentimes call an MCA. So you filed an answer, then you filed a motion to compel arbitration, probably from our site, which is a good move. Definitely, we see a lot of people get their cases dismissed by filing an MCA. And then the plaintiff, it looks like I got that backwards actually. Let's see. So they filed for discovery, and then you filed the MCA. So this is like a bit of a nuanced situation. It really comes down to like specific things in your court and your state, etc. Generally speaking, like you do one motion at a time. So if they filed some kind of a motion, I'm not sure exactly what that'd be in discovery, but if they filed some kind of a motion, then you want to respond to that by filing a counter motion and then a memo opposed to the motion. And then there's a hearing on that, and then the judge will rule on it, and then you file another motion, in this case, motion to compel arbitration, and the judge will go through that process again, motion, memo, hearing, and then the decision will be made on that. If you're compelling arbitration, maybe there's a pause put on other motions, other things going on in the lawsuit. It's totally possible. But it kind of comes down to like the nuances of your case. Just to be safe, you probably would want to respond to the discovery motion. All right, Sean. As of 2 days ago, I'm using you folks to answer my summons. Great. What do I do now? Do I sit and wait to be contacted by the creditor, or do I do something else? It's up to you to determine like what kind of result you want. Again, basically for me, it hinges. Do you feel like you owe part of the debt? If you do, you should go for settlement. Settlement is going to be a better resolution than even getting the case dismissed if you owe part of the debt, because it'll get it settled on the credit report. They won't be able to come after you outside of court, and it will fully resolve the lawsuit. Sometimes things get dismissed, but it's only dismissed without prejudice, and then they just sue you again in court. Whereas if you settle the debt, you're fully settling this line of credit. If you do want to settle, definitely go over solosuit.com/solosettle, and then do the premium service. Just taking a look at what that looks like. I find it helpful to pull that up sometimes. So let me do that. All right, so here we go. We're on the site solosuit.com. So if you want to, first off, we will click like the reply to a debt lawsuit button. In this case, once you've already done that, you just click a settle a debt lawsuit. Click get started. Most of you probably already have an account, so you'll go there to log in. And then let's see. And you just continue through here. It'll ask you like a lot of the same questions as when you did an answer document. So you'll just type those things in, do a first and last name here. And then at the end of this process, it'll ask you to make a settlement offer. If you're doing solo settle premium, you can probably just start with like a low ball. If you aren't planning on doing premium, you probably want to start with something more realistic, like at least 40% of the debt probably in most situations. And then once you go through that, you can pop up onto here. Let's see. That's not right. Okay. And then once you're there, then you'll fill out this form to activate Solo Settle Premium. You just type that in. You type in the amount, and then you just make a payment on here. Alrighty? Alright, so that's the general idea. So in most cases, you probably want to make an offer to settle using Solo Settle Premium. Alright. I used SoloSuit to file my answer. They didn't file proof of service by mail though. Interesting, but thanks for letting us know. All of our answers include a certificate of service, and note that we file things by mail. Reach out to us at support@solosuit.com. We're sure we can get that figured out for you. Even if that isn't included, we rarely see that cause a problem for anybody. All right. Creolac. Hi all. Question: I sent the response letter to a summons with a settlement offer. So I sent a response letter to a summons. So you filed an answer with the settlement offer. It sounds like. How long does this take to get a response? I haven't received any notice from your lawyer. Okay, I guess if you could provide some more information there. I'm not exactly sure what you're saying. If you receive the summons and a complaint, you want to file an answer document, right? An answer, and then after that, then you make an offer to settle. Sounds like maybe you got a summons and a complaint, and then you just tried to settle. If you try to do that, they'll just file for default judgment against you. They don't have any interest in settling with you until you've filed an answer. And then I'm not exactly sure what you're referring to as far as our lawyer. We don't employ any lawyers. We have some attorneys that we partner with to do the review, or we have like the partnering law firm for Solo Settle premium stuff. I'm not sure exactly what you're referring to. Maybe give us some more info in the chat. All right, Sean. I'm also in the same process as the other Sean. How long after sending an answer can I settle? Also, I denied everything, but can I just settle to end the process? Yeah, so denying everything in the answer document and then offering the settle is totally fine. Denying isn't the same thing as saying this isn't true. It's more like saying I want the other side to prove that that this is true, right? So yeah, usually what people do who are most successful through this process is they use us to file an answer, and then they'll just go right over and make an offer to settle. If it were me, I'd probably do both of them in like the same day on our website. So no need to wait. You can just make an offer to settle right now. And if you really do want to settle, if like you really want this case to settle and you want the best results, Solo Settle Premium is definitely seeing the best results right now. Okay. Just on that, so far out of our June cohort, so like out of the people that came to Solo Settle Premium in June, just about 90% of those cases have settled favorably in terms that like the people are happy with. Whereas with just regular Solo Settle, it's a much smaller amount. Solo Settle Premium is getting the best settlement results for sure. All right, Patrice. We used you all to answer a lawsuit, and the attorney sent us an offer to settle. Great. If we don't accept the offer, what happens next? Yeah, so if you decline to settle, so the attorney sent you an offer to settle, that's something that we see happen quite a bit. If you want to decline that, then that offer is off the table. Right? You decline it, off the table. Even if you counter offer, if you make a counter offer, their initial offer is going to be off the table probably. So if you decline it, then you can make a new offer. You can do nothing. You can just wait and see what happens, or you can file other documents in the lawsuit. We don't really have many services around helping you file additional documents like one-off throughout the lawsuit. Mostly our service is focused around filing that first answer and then helping you settle. People who really don't owe the debt, oftentimes their cases get dismissed after filing an answer. If you do owe the debt, it's probably not going to get dismissed after filing an answer. All right. Christian, I completed my medication. Now I have received a letter for pretrial. What should I expect? It seems like perhaps you meant mediation instead of medication. Probably completed a mediation session between you and the other party, trying to talk things out. Looks like there was no resolution that you reached. Now there's a pretrial hearing scheduled. So in a pretrial hearing, usually you show up, the plaintiff shows up, the debt collector, and then the judge. In that hearing, the judge will again probably ask, have you guys tried to settle? Can you settle? If not, let's schedule a hearing. And then there'll be a date set, and you have to show up in court for that date. That's pretty much what happens in the pretrial hearing on these cases. Usually they're pretty straightforward. All right. Barry Spurlock, the plaintiff filed an affidavit with the summons, and the affidavit states the collection agency can collect on behalf of the original creditor. The original agreement that I signed is not in there. All right, interesting. There's no question in there, so I guess I'm not sure what kind of answer you're looking for. Affidavits are basically just statements. Basically statements that are sworn. It's kind of like in a movie where you watch a witness say stuff on the stand. It's kind of like that, but on paper instead, and no one's asking them questions. So they're just kind of giving their legal testimony on a piece of paper. Affidavits in this case are pretty common, where the original creditor testifies that they sold the debt to the new plaintiff, like the debt buyer. If the original agreement is not in there, that is suspicious. It's something that we see a lot, and you might be able to poke holes in their case by saying, hey, they can't prove that I owe the debt because they don't have the original agreement, and that's a pretty strong case in my mind. But again, it depends on the court, depends on the judge, depends on the state. The idea here, basically the path to winning these trials, it kind of comes down to the idea of burden of proof. So the burden of proof is on the plaintiff in these cases. So that means the debt collector needs to prove that you owe the debt. It's not up to you to prove that you don't owe the debt. Alrighty? Alright. Let's see. Just looking for the next one here. Bruce, how can you prevent the judgment if you plan to settle? Well, that's pretty straightforward, really, right? So, what happened, like, judgment on the case timeline is like somewhere way out here. There's a bunch of things that usually happens before judgment. But basically, if you file an answer, and then at any point in time, you can kind of get out of the trial process to settle. But after you file an answer, you can just make an offer to settle. And then if it settles, then judgment is avoided. There you go. With Sole to Settle Premium, the partnering law firm will make sure that all of the documents are filed properly for you. Usually that means that a stipulation of judgment or a stipulated judgment is filed. And what that means is that judgment is stipulated upon certain conditions. So basically what it means is that the two parties have reached the settlement. If the defendant follows through and makes the payments as they have agreed to, then no judgment will be filed and instead the case will be dismissed. However, if the defendant doesn't make the payments, then a judgment will be filed against them and they have already agreed to that judgment. That's usually what settlements look like in these cases. Alicia, can you settle with payments or does it have to be a lump sum payment? Good question. Another great reason for Sole to Settle Premium is that it costs the same amount of money as regular Sole to Settle, but it does support monthly payments right now. So if you want to do a monthly payment plan, that's the way to do it. How long does it? We got Creole Lack. How long does a response take? I used Sole to Settle about 1.5 weeks ago. Yeah, so with Sole to Settle Basic, it's like the non-premium version. Most attorneys, if they're going to respond, they respond within about 1 day. So if the collector hasn't responded and after like 3 days, they probably aren't going to respond. If you want to settle and you want them to like respond, Sole to Settle Premium then is the path for you. It's unlikely that they're going to respond or engage in the settlement just through regular Sole to Settle. Right? Top line. Hey, I want to say thanks for your program. The court sent me a response. Thank you. Glad that it's working for you. That's great. It's fantastic. Is there a technique way I can't afford an attorney? Top line, I'm a little confused here. This is the court response. Just grab my little pencil there. Usually the court doesn't respond in these things. Usually the court isn't responding. Like usually documents are coming either from the defendant or the plaintiff in lawsuits. So I'm not exactly sure what you mean there. Basically, yeah, if you wanna respond, if you wanna get the case wrapped up, Sole to Settle Premium is the way to go. It's much cheaper than an attorney. For most people's cases, usually you're getting a huge discount on what a regular attorney arrangement would cost. Sanzi, my lawsuit went through the court and was issued a summary judgment. Can I still negotiate and settle using Sole to Settle in this case? So Sole to Settle Premium is only for like lawsuits pre-judgment. They don't help if there's been a judgment. Summary judgment is kind of surprising. It sounds like if they filed a motion for summary judgment and then you didn't file a counter motion, motion for summary judgment is probably just going to be granted. But if someone is facing a summary judgment, a motion for summary judgment should definitely file a counter motion. The plaintiff should not win a motion for summary judgment if you are denying things in the answer. You can still negotiate even after they get a judgment. Terms are just going to be much harder. You can certainly send an offer on solo settle. It doesn't hurt, but they might not engage. Usually, like at this point, you're trying to stop them from garnishing your wages. It's probably going to take a pretty enticing lump sum offer to get that thing settled. All right. Let's see. Bruce, my creditor is refusing to settle for less than the amount owed. What can I do? I guess the question is, have you just tried settling on your own? Like, have you contacted them and settling, and they're refusing to settle on that path? Have you tried solo settle to settle? Have you tried solo settle premium? Usually we see when people escalate to solo settle premium, they get much better results again. Just because you are going to have the backing of a law firm, and they're going to take you a lot more seriously, and they're going to settle. They're going to be much more likely to settle. All right. Patrice, we filed an answer. Is it too late to do an arbitration? No, it's not. Usually people do an answer first, and then after that, they do a motion to compel arbitration. And that's a good way to go. Erica, hello. My case is headed to trial. No date yet, but would like to know if it's too late to file an arbitration. The case is with Midland. Nope, it's not too late to file an arbitration. You can go ahead and do that. Again, if you owe part of the debt, you probably want to file an answer, and then you can try filing a motion to compel arbitration. But then you also want to make an offer to settle. In most cases, certainly up to you, but that's what we see gets the best results. All right, Alicia, what exactly is arbitration versus filing an answer? So on loan agreements, especially credit card agreements, it's really common to have an arbitration clause in the agreement. The arbitration clause says that if one party sues the other party, the person being sued can opt for arbitration. Either party can opt for arbitration. Arbitration is a way to resolve a dispute outside of court. And it's usually faster, cheaper than court. That's why people like it. So instead of going before a judge, you go before an arbitrator. It's basically like a private court system. So a motion to compel arbitration is a document that oftentimes in these cases is filed by the defendant that requests the judge to arbitrate, to compel arbitration, to move the case to arbitration. So it's a motion, right? All motions are just asking the judge to do something. In this situation, it's asking the judge to move the case to arbitration from out of the court. It's triggered it's backed by that clause in a credit card agreement. If your loan agreement doesn't have an arbitration clause, then you can't really compel arbitration. It's all about the contract. Alrighty. Cheryl, and we're about at time. We wrap up half past the hour. I'll try to go rapid fire on some of these last questions and help you guys out. I am disabled and got SSI and survivor benefits for my daughter. What should I do? Sounds like you're worried about those being garnished. Again, you just want to respond, file an answer, make sure you protect yourself from default judgment, and then make an offer to settle. Barry, would the affidavit be considered hearsay? There's a standard agreement with the affidavit. That is not even a complete argument without any signature names. Yeah, maybe. Kind of going a little bit technical. Basically, the main idea is you just want to prove that they can't prove that you owe the debt. Glenn, do I need to submit an answer before I settle, or can I settle directly without filing an answer? You don't have any leverage to settle until you file an answer. So you want to file an answer and then make an offer to settle. Bruce, will the motion to compel arbitration delay until I can pay? Yeah, motion to compel arbitration can delay. Yep. Sometimes people just won't, like the plaintiff won't do anything after you file a motion to compel arbitration. It depends, but it can be used that way. Christopher, when copying plaintiff with the answer filed in court, do you include the court-stamped proof of filing? That's a good question, Christopher. We don't at this time include that in like all situations. We do somewhat of like a standardized method, and we do what we track our success rate on filing very closely, and we have a very low error rate. Sometimes courts do like reject our answer document just to be transparent. It happens very infrequently, but it does happen. We keep really close watch of which courts are doing that and why, so we can like make sure it doesn't happen in the future. But like, you know, even attorney documents get rejected from time to time by courts, and we have found that infrequently, if ever, does anybody actually care if like the court stamped proof of filing document is included when the plaintiff receives their copy of the answer document. I've never spoken with a single person who has had a problem with our method of doing things where it's like caused a problem for anybody. All right, so that's why we do how we do it. All right, Glenn again. I want to settle with lump sum if I can avoid the entire court process. Yeah, that's great. Yep, lump sum settlements get the lowest percentage, get the lowest proportion, get the best deal. So that's great, and you can definitely avoid the court process by settling. All right, Shell. I was told I sued state, but no notices were given. Everyone is filing ACCTI and taking co. I'm not sure what that means. I'm not sure what that means. Sorry, maybe you could re-put that in. Maybe Hannah got to your question. Don't sleep. I sent an answer and got my court date back on September 20th. What happens when I get to the court? So you can watch our video. We got a bunch of YouTube videos about how to prepare for court. Basically, you just want to bring a bunch of documentation. Bring all the documentation showing that you have paid off the debt, or that it's not your debt, etc. Or basically bring your game plan to make it clear that the other side cannot prove that you owe the debt. All right, looks like Hannah links to that video. Alrighty, so just in conclusion, Hannah, thank you for attending. Thanks for coming out today. Love seeing you guys at the webinar. Love helping you out. As always, we are rooting for you. We want you to win your case. Happy to do what we can to help. And in summary, if you got a complaint, if you got a summons and a complaint, you want to file the answer document, and then you want to make an offer to settle, probably using SoloSettle Premium. If you want in there, if you have an arbitration clause in between, you can file a motion to compel arbitration. All right, that's the rundown, guys. Good to see ya.